You are watching PR English Shorthand Dictations YouTube channel.
This is English Shorthand Dictation number 297 and the dictation speed is 100 words per minute. Ready? Start. I am extremely glad to be present here at the valedictory session of the Platinum Jubilee celebrations of Income Tax Appellate Tribunal. The tribunal, which was set up in 1941 to function as an impartial quasi-judicial body to resolve the disputes between the revenue and tax-paying public, is completing 75 years now. The concept of tribunals has been borrowed from the French judicial system, which had a set of administrative courts that ran parallel to the civil courts. The intention behind this system was to ease the civil courts from administrative matters while laying separate standards for administrative disputes. The modern Indian Republic was born as a welfare state, and thus the burden on the government to provide a host of welfare services to the people was immense. The quasi-judicial powers acquired by the administration led to a huge number of cases with respect to the manner in which these administrative bodies arrived at their decisions. The vast number of welfare legislations, coupled with the right to judicial review, was thought to burden the civil courts with more matters than they would be able to handle. Thus, various tribunals for income tax matters, railway rates, labor matters, and company courts were given statutory legitimacy to function parallel to ordinary civil courts. The French system of tribunals is in contradistinction to the rule of law, where everybody in a state shall be subjected to some common law, and there is no need for extraordinary tribunals to deal with cases of government and its servants. As per rule of law, it was unusual that when the injured individual sought protection against the administration, he had to turn to an administrative body which was certainly closer to the administration than the judicial courts. In India, the adjudication of administrative disputes has been commented by the judiciary through various cases placed before it over a period of time. As of now, we understand that a complete adaptation of French system is not possible in India because judicial review of tribunals' orders cannot be fully removed, with judicial review being an integral part of our constitution. While the matter seems to be put to rest with Supreme Court's famous decision in Chandra Kumar's case, the debate has not ended yet, and much remains to be debated in the context of working, independence, and efficacy of the tribunals. There have been many success stories of the tribunals, yet there have been instances of delays and favoritism as well, though the courts have consistently held that these bodies must maintain procedural safeguards while arriving at their decisions and observe principles of natural justice. Yesterday, during the inauguration of Platinum Jubilee session, when Honorable President of India was also present, I had briefly touched upon the criticism of the tribunalization of justice from some quarters. while in some quarters increasing tribunalization has been criticized as an encroachment on the judiciary's independence and contrary to the constitutional scheme of the separation of powers between judiciary and the executive. The other concern has been that though they were supposed to address the issue of delays and pendency in the existing judicial system, they seem to be bogged down with the same problems. It is also alleged that the tribunals lack independence and are not better than the administrative arm of the ministries. One thing is clear, that the tribunals are here to stay. The tribunals play an important role in the sphere of the adjudication of disputes. Tribunals function differently from courts, from the manner of appointment to the procedure followed. The tribunals do not have to follow the uniform procedure as laid down under the Civil Procedure Code and under the Indian Evidence Act, but they have to follow the principles of natural justice. Nevertheless, they seek to achieve the same objective as that of the courts, and that is to impart and deliver justice. Friends, within the four walls of judicial review, the tribunals carry a great responsibility of not only resolving disputes but also exhibiting higher standards of performance, as mostly the tribunals have been reviewing or overseeing appeals from the actions of the administration. The effectiveness of the tribunals can be gauged, and in fact, the very objective of setting up of the tribunals can be said to be fulfilled only when the tribunals come up to the expectations of its stakeholders. If the litmus test is that whether the institution is maintaining consistency of being fair and judicious, apart from rendering speedy justice, I think the Income Tax Appellate Tribunal has passed with distinction. Working of the institution depends upon the reputation which it builds up over a period of time, and the Income Tax Appellate Tribunal has lived up to the expectations. Friends, we must recognize the intrinsic link between the simple tax dispute resolution mechanism and the effect it has on overall economic growth of a country. A good tax administration, which includes an efficient and prompt tax dispute resolution mechanism, plays a major role in the growth of a globalized economy, either in general terms or in specific sectors, like improving ease of doing business or attracting foreign investment. Tribunals are important instruments of governance and must function in fair and judicious manner outside the regular cumbersome judicial process. While the Income Tax Appellate Tribunal strives to achieve the mandate assigned to it, I am of the view that it must constantly evaluate its internal procedures to look for the avenues for improvements. Whether it is digitization of documents or setting up of e-courts, the Income Tax Appellate Tribunal must find new ways and means to speed up disposal for time-bound justice. There is an immediate need for taking up reforms like pre-trial hearing, which is so popular in developed countries. Improvement of infrastructure wherever necessary must be aggressively pursued. The requirement of skill upgradation through various learning techniques and evolving with the new developments in taxation following socio-economic revolution in the last 3 decades or so, and India's increasing presence across the globe can hardly be overemphasized.